of their joint statement of defense. Thus, the plea is sufficiently raised before the court for the court to consider same. The claimant, though, did not file a reply to the statement of defense. The apex court has held, in the case of Abubakar and BOAP Limited, that where a claimant does not file a reply in respect of res judicata raised in the defendant's statement of defense, the effect in law is the same amounts to a denial of the material allegations, and there is an implied gender of issues on the defense of res judicata. Thus, it is immaterial that claimant in this case did not file a reply in respect of the res judicata raised in the statement of defense of the defendants. The apex court in the case of Jimo and Akande held that the effect of a successful plea of res judicata is a dismissal of claimant's claim. As such, it is the duty of a party who raises same to prove it. See by Courtney Limited and Aso Savings Limited Supra. As such, a party who intends to move the court to invoke the doctrine of res judicata to bar an action have to show that the following conditions for a successful plea exist. That is, 1, parties or their previous in both the previous and current cases are identical. 2, the subject matter issues or issues in both cases are the same. 3, the previous judgment was rendered by the court of competent jurisdiction and is a final judgment, valid and subsisting. And 4, that the previous suit conclusively determined the issues between the parties. See the case of MV Samson versus IBG Investment Company Limited, Ezwala and others versus Uga and others, Yanati Petrochemicals Limited and EFCC, and Ibeke and Okadibu. I must say here that where a person is a party for the purpose of application of estoppel perem judicata refers not only to parties on record, but also their previous, and previous include all those who are previous to the parties on record in blood or title or interest, and those who may be interested in the outcome of the case being litigated upon, including those who ought to have been made parties. See the case of MV Samson and IBG Investment Company Limited, Supra, the case of Adalma Tankers Bunkering Services versus CBN Citation Captured. It is worthy of note that for a successful plea of estoppel perem judicata, all these conditions must coexist. Therefore, failure to satisfy one of the constituents of the whole will render the doctrine of res judicata inapplicable or impotent. The determination of whether parties or their previous are the same, whether subject matter or issues are identical, as well as are the same, is entirely a question of fact to be gleaned from the parties' case. See the case of Zubair and Kolawole, Anwoyi and Shodeke, the case of Ekong and Udo. The defendants, by paragraphs 3 to 6 of their affidavit in support of preliminary objection, contended that this suit is cut off by res judicata and thus constitute an abuse of the process of court. They were further to state that the subject matter of this suit, as previously constituted, is the same with the subject matter instituted by the claimant in suit number NICN/FKJ/07/2018. It was equally deposed that the same issues, claims, or subject matter of the present suit having been fully heard and determined between parties in suit number NICN/LKJ/07/2018 cannot be relitigated before the same court. Claimant viewed paragraph 3 of the counter affidavit and reply on point of law. In response to the defendant's preliminary objection, averred that the subject matter or cause of action in suit number NICN/LKJ/07/2018 is for reinstatement from wrongful or unlawful termination, while in the present suit, it is for payment of salary for work done after reinstatement. It is a tried position of the law that in determining the existence of the above conditions for a successful plea of estoppel perem judicata, a court before whom the plea is raised has the duty to thoroughly and not superficially investigate the relevant processes before it in order to ascertain whether the plea applies. To avoid falling into an error that may lead to injustice, see the case of Kambaza and Hakimi and another, Okungbowo and others, and Governor of Edo State and others. In order to do this, the court must do a careful study of the entire evidence of record to see if they disclose that the subject matter of the previous proceedings is the same with the one in dispute in the present action. See Adigo and Governor of Osun State. In line with the above duty, I have carefully considered the originating process along with the accompanying processes filed in this suit. I have equally perused the copy of the judgment in suit number NICN/LKJ/07/2018, which was pleaded and annexed to the originating process filed by the claimant and also tendered and admitted as SBJ. Parties in the previous suit are the same with this one, except for the first and third defendants in this suit, who though were not parties in the previous suit, but are nonetheless previous of the second and fourth defendants herein respectively, who were also parties in the previous suit. There's equally no doubt that judgment in suit number NICN/LKJ/07/2018 is a final decision handed down by a court of competent jurisdiction. However, the dispute between both parties seems to be whether or not the subject of the action is the same with the one in the present suit. It is clear from the consideration and perusal of the evidence on record that SBJ, when compared with the present one, that the cause of action in the previous suit is for wrongful termination of employment of the claimant, in respect of which the court delivered judgment in his favor, ordering his reinstatement, and parties are addendum as to the fact that claimant was reinstated and paid his arrears of salaries, while the cause of action in the instant suit is for non-payment of accrued salary for work done by the claimant after resuming work at the third defendant. In fact, the main claim in the present suit is accrued salary after reinstatement, that is, the cause of action in both suits are not materially the same. It is clear from the above and admittedly, as rightly submitted by Learned Claimant Counsel, that the plea of estoppel parem judicata cannot operate in this case, as the cause of action of subject matter in the previous suit number NICN/LKJ/07/2018, and the one in this present suit, the different in both cases, and the one in this present suit are different in both cases. The clear answer to issue 1, therefore, is that the judgment of this court in suit number NICN/LKJ/07/2018 is not estoppel to the present suit. This issue is therefore resolved in favor of the claimant. Consequently, the defendant's preliminary objection on the issue of res judicata is dismissed. I so hold. It was also noticed that the defendants, by paragraph 10 of their joint statement of defense, averred that claimant's action is without reasonable cause of action, leaving with the court with no jurisdiction to entertain same. The above facts were also deposed on paragraph 6 of the affidavit in support of the notice of preliminary objection. However, the defendants, whether in the written address in support of the notice of preliminary objection or in their final written address, failed to address the court in respect of the above ground of objection to the jurisdiction of this court. The law is of common that an issue or a preliminary objection in respect of which no argument is advanced in the brief of argument and therefore not canvassed before the court must be deemed abandoned. See the cases of Kappa and Alberto Nigeria PLC and NDIC, the case of Onamade and ACB Limited, and the case of Lemboye and Omosiji. The ground of objection in paragraph 10 of the joint statement of defense as to the failure of claimant's action to disclose reasonable cause of action in respect of which no argument is offered is hereby discountenanced. It is in view of all the reasoning above that issue 1 for determination is hereby resolved in favor of the claimant and against the defendants. Now to issue 2, which is the merit of the case at hand. It is clear from the claims of the claimant that he is seeking for salary and allowances for work done. The claimant, as stated earlier in this judgment, is suing for payment of his salary for work done since resumption to duty in the third defendant upon his reinstatement by this court. The defendant, on the other hand, is contending that claimant has been paid his salary and allowances due to him as at March 2020 in the sum of 4,377,228 naira, and that all allowances of civil servants in the employment of a second defendant are scheduled and paid accordingly without leaving anyone out. However, that of the claimant was delayed due to the process of restoring his name on the payroll after screening process and subsequent court proceedings. They maintain that after suit number NICN/LKJ/07/2018 was concluded, claimant was paid, but that due to economic situation of the country, there are several staff of the state and that of Ibaji local government who have not been paid, but payment are subject to availability of funds. The defendants are not denying that claimant worked from September 2018 to September 2022, but that he was paid up till March 2022, and that due to economic hardship, defendants are owing several of their staff, which indebtedness will be redeemed subject to availability of funds. It is settled law that where a claimant fails to file a reply to averments in the statement of defense which have not been taken care of in the statement of claim, he would be deemed to have admitted the averments in the statement of defense. See the case of Bindi and Bashiru and others, Usman and First Bank and others. Claimant in this case did not file a reply to deny being paid the sum of 4.3 million naira as alleged by the defendants. In fact, claimant, while under cross-examination by Learned Defense Counsel Ojo Okaye Esquire on 21st of February 2023, admitted that the defendants have complied substantially with the judgment of the court in 2018. Also, Learned Claimant Counsel on 25th of January 2024, while cross-examining DW, asked if Exhibit Gabriel is the evidence of last payment made to claimant and that the payment was made pursuant to the court's judgment earlier, to which he answered emphatically in the affirmative. It is thus not in doubt that claimant has been paid the above sum averred by the defendants in their statement of defense. It is therefore expedient to consider the entitlement of claimant's salaries after the said period. As stated supra, the defendants have not denied that claimant did not work for them. Also, claimant, while under cross-examination by the defendants, stated that he has resumed work with the defendants after the court's judgment, but has not been paid, and which position has not been controverted by DW. There's no doubt that an employee is entitled to salaries for work done. See the cases of Spring Bank PLC and Babatunde Adedayo and OAUTH CMB, the case of Rashid Adigo and others in Nigeria National Petroleum Corporation NNPC. Thus, there's no doubt that claimant is entitled to be paid for work done. However, it needs to be stressed here that claimant herein by his reliefs is claiming entitlement for sums representing his salaries from September 2018 to the month of September 2022 and allowances for 4 years being the sum of 5,712,000 and 800,000 naira respectively. The law is right that monetary claims are in the nature of special damages which are exceptional in character. Therefore, they must be claimed specifically and proved strictly. All the sum claimed on every item must have been crystallized in terms and value. Thus, claimant must, of course, plead with distinct particularity how he came by it. Excuse me. So the case of Dakwa and OA Nigeria Limited, case of Essian and Samuel and others. Claimant in this case failed to even plead the sum of 5.7 million naira and 800,000 naira he's claiming in his reliefs as arrears of salaries and allowances respectively. He merely pleaded his monthly salary without pleading the above sums he's claiming in his reliefs. It must be noted that reliefs claimed are not part of pleadings. See the decision of the Apex Court in the case of Trade Bank PLC and Pharmatech Industries Product Limited. The case of Ishola and UBN Limited. Thus, claiming a sum in a relief is not synonymous with pleading that sum with specific particularity. In any case, it is settled law that reliefs claim in a case must be based on facts in the burden of pleadings. This is because the facts pleaded are foundation on which the reliefs must be based. See the case of Monotechnics, SAMS Limited, and HMCS Limited, citation captured. The failure of the claimant to plead in his statement of facts the particular sums of 5,712,000 and 800,000 naira respectively claiming his reliefs are fatal to his case. Also, claimant failed to distinctively plead how he came by the quantum of the sums claim, which are special damages, which is equally fatal to his case. Apart from satisfying the requirement of pleading, Claimant has reason supra is also by law to strictly prove how he came by the quantum of the sum claimed. A claim in the nature of special damages to succeed must be proved strictly. The court is not entitled to make its own estimate on such a claim. Claimant has to satisfy this requirement by adducing credible and cogent evidence in support of the sum claimed. In law, proof of entitlement in such instance is often by reference to an instrument which grants same. See the contributory judgment of Oyewumi GSC in the recent decision of the Supreme Court in the case of Skybank PLC versus Mr. Adedoto Olusegun Adegun on reported appeal number SC/406/2018, a judgment delivered on the 27th of February 2024. Claimant in this case had relied on SBJ1 in proof of his monthly salary. It is imperative for this court to, at this stage, ascertain the status of SBJ1, which was admitted under protest by the defendants. Learned counsel for the defendants, Ojoka Esquire, has submitted written arguments regarding the defendant's position on the matter that the said SBJ1 is a public document, which the only admissible secondary evidence thereof is certified true copy. It is equally a submission of counsel that SBJ1 is inadmissible because its authenticity is in doubt, that the maker is a stranger to this case, having not been called as a witness. Claimant's counsel, Oboni Esquire, in his response, urged the court to discountenance the argument of the defendants as same is misplaced because they are not contesting the authenticity of the said SBJ1, neither are they denying its existence. He relied on Section 12 of the National Industrial Court Act 2006 in the case of Victor Adegboye United Bank for Africa, Supra. Now it needs to be iterated that generally courts act only on legally admissible, relevant, and credible evidence. See the case of Benjamin and Kalio, the case of Udoro and Governor Akwa Ibom State. It is therefore expedient for the court to consider whether SBJ1 is admissible in law. The ground of objection, as stated above, is that SBJ1 is inadmissible for being a photocopy of a public document which is not certified in line with the provisions of the Evidence Act. The question that would come to mind at this stage will be what kind of document will qualify as public document. By Section 102 of the Evidence Act, the following documents are public documents. A, documents forming official acts or records of the official acts, the sovereign authority, official bodies, and whether of Nigeria or elsewhere, and B, public documents kept in Nigeria or private documents. See also the case of Muhammad and Tijani, citation captured. Flowing from the authority cited herein before, and by the provision of Section 102 of the Evidence Act, I find that SBJ1, which is titled Reimplementation of the Payment of 18,000 Naira minimum wage in Kogi State local government areas, emanated from Ministry of Local Government and Chieftaincy Affairs Office, an official body, and thus a public document. It is true that the only categories of public document that are admissible in evidence are either the original document themselves, or in the absence of such original copies, they are certified copies and no other. See the case of Akiri and Emmanuel and Section 105 of the Evidence Act. The position of the law is very clear as regards the admissibility of public documents, in that the only admissible secondary evidence to prove a content of a public document is certified true copy of the original and no other. I peruse SBJ1, and I find that it is a photocopy of a public document which is not certified in line with the provisions of the Evidence Act. In the absence of certification, such documents are not admissible evidence, and if admitted, the same cannot be acted upon. See Dangoji and Abdulkadir and another, the case of Adibowale and Nigerian Army. I must say at this stage that I bear in mind the submission of Learned Claimant Counsel in his final written address, wherein he urged the court, while relying on the case of Victor Adegboye and United Bank for Africa Supra, to invoke the provision of Section 12 of NICA to admit the said SBJ1. This court, no doubt, has power under Section 12(2)(b) of NICA to depart, just a minute, to depart from the provisions of the Evidence Act in the quest for substantial justice. This power is to be exercised judicially and judiciously, in the sense that it should only be invoked when it would do substantial justice for a case. As such, it is sparingly used and only used in deserving cases. I do not think this case is one of such deserving cases, in the sense that even if the court departs from the provision of the Evidence Act to admit the exhibit, claimant case will still not be rescued because claimant has even failed by his pleadings to plead the sums claimed in this case. Admitting the said exhibit will not even have any probative value on the case of a claimant, as he has, by his pleadings, not done the needful. Also, as a public document, the requirement of the Evidence Act is germane and must be complied with, more so when the authenticity of same is being questioned by the defendants. This court, therefore, does not find any reason in this case to exercise its discretion under Section 12(2)(b) of NICA in favor of the claimant. Howbeit, the position of the law stands firm that where a court inadvertently admits an inadmissible evidence, the court must at the stage of judgment expunge same from its record. See Momodu and Ibrahim. Notwithstanding the fact that the said SBJ1 was admitted during trial, since same is legally inadmissible, this court has power to expunge same at this stage of judgment. It is in the light of all stated supra that I expound or jettison the said SBJ1 from the list of exhibit admitted, having fall short of a provision of Section 105 of the Evidence Act, I so find and hold. Let me also use this opportunity to address the other objection raised in the final written address of the defendants. It needs to be stated at this stage that no matter how trivial or irrelevant a submission of counsel may appear, a judge has a duty to examine it and rule upon it. See Odunakwe and Ofomoto and another citation captured, Olowolagba and others versus Bakari and others. Learned Defense Counsel read paragraphs of his final written address, purports to object to Exhibit A. Exhibit A series, particularly Exhibit A, A1, A2, A3, A4, and A5, which are, according to him, claimant's witness could not speak to and also cannot be examined on. I need to state here that there are no such exhibit before this court. Only Exhibit J series, that is J to J1, J and J1 tendered on the 21st of February 2023, and Exhibit Gabriel tendered on 28th of January 2024 are before this court. I therefore cannot fathom how counsel came by the purported Exhibit A, A1, A2, A3, A4, and A5, which he sought to object to in paragraph 4.3 of his final written address. It is known in saying that the court is enjoined to espouse its record where counsel in his written address misconstrues the facts or evidence in a case. This is particularly underscored by the position of the law in decided cases that the address of a counsel is only meant to assist the court to arrive at its decision in the case. Whatever address the counsel present to court, no matter how brilliantly or tendentious, cannot be of any compelling or preemptory force on the judge. See the case of Ajayi and Udobi. Counsel cannot, while addressing the court, allege facts not contained in the evidence before the court. Therefore, addresses or any argument of counsel based on or alleging facts not contained in the records of this court are not competent and valid for consideration. See the case of Nwachukwu and another, and AG Anambra State and another. There is therefore no doubt that the Learned Defense Counsel blundered in its submission reproduced above. But cases cannot be decided on the basis of the blunder of counsel. Thus, counsel cannot make false hypotheses and expect the court to be bound by such. I've considered the record and there is no such exhibit before the court as I've stated supra. It is in the light of the above that I discountenance with the submission of Learned Defense Counsel in paragraph 4.3 of his final written address. The above being said, there is no evidence before this court in support of either the sum claimed as areas of salaries and allowances by claimant. There's equally no evidence in support of a sum of 119,000 naira claimed by claimant as his monthly salary. The court cannot speculate on issues which are wholly unproven by evidence placed before it. The court is not allowed to go outside the gamut of evidence before it to shop for materials upon which to use to decide the case before it. See the case of Lawan Abdullahi Ibupa, Wasa, and others versus Tokshahi, Kara, and others, Okparaji and Uhanu, citation provided. Reliefs are not granted as a matter of course. Basically, the law requires a party seeking for such to substantiate his claims. With credible, cogent, and verifiable evidence. It is thus clear from the above that claimant's claims for the sum of 5,712,000 and 800,000 naira respectively must fail, not only for failure to plea and particularize them, but also for lack of proof, notwithstanding that the court has found earlier that is entitled to be paid salaries for work done. Accordingly, reliefs 1, 2, 3, and 4 in the general form of complaint fail in their entirety. I'll take reliefs 5 and 6 together. Claimant by reliefs 5 and 6 seek for order of this court, asking the defendants to pay him cause of action and general damages, respectively. There is no gainsaying that the law stands firm that where claimant is denied of his reliefs in the main, then any incidental reliefs are ipso facto denied. It naturally flows as you cannot put something on nothing. See Olayemi and FHA, citation provided, McDonald's Scientific Emporium Limited and Access Bank, citation provided. The reliefs on cause of action and damages being incidental reliefs in this case can therefore not stand in view of the failure of the main reliefs 1 to 4 above. Accordingly, reliefs 5 and 6 in the general form of complaint also fail. The proper order to be made in this instance where claimant has failed to prove his case is one of dismissal of his claims. See the case of Abuja and another versus Ohuda, citation provided, Omoride and Eliazu and others, citation provided. The claimant has failed to prove his claims before this court, and as such, his claim is entitled to be dismissed. It is in consequence of this that I dismiss claimant's action in its entirety. Judgment is accordingly entered. Parties are to bear their respective costs.
As the court pleases.
So a copy of the judgment will be sent to you in Lokoja.
Lord, we appreciate my Lord, sir, for the well-considered judgment, sir. We are grateful.
Very well. So arise.